Hello everyone, welcome to Apurva's Legal Bites. Today's topic is on caveat. In Latin, caveat means to be aware, and in law, caveat means it is a request made or a notice given by an individual to the court, asking the court not to act in a certain manner without informing him. Actually, there is no exact definition for this caveat, but however, section 148A of CPC talks about it. This section has twofold purpose: to safeguard the interest of the caveator and to prevent the multiplicity of the proceedings. So in caveat petition, there are two parties, caveator and caveatee. Caveator means a person who files a caveat is known as caveator, whereas the opposite party means the opponent is caveatee, means a person against whom the caveat has been filed is known as caveatee. Okay, and in a case, the court defined caveat as a warning or a caution given by a person to the court that no order or relief shall be passed without giving notice and without hearing the caveator. And here you must remember two important points. The caveat petition can be filed only by the party to the suit. It cannot be filed by a person who is completely a stranger to the suit. And this caveat petition can be filed only in respect of civil proceedings. It cannot be filed in respect of petitions under CRPC and also the petition under Article 226 of our Indian Constitution. Now let us see what does this section 148A of CPC talks about. First, who may lodge a caveat? Any person claiming a right to appear before the court when an application is expected to be made or when an application has already been made in a suit or proceeding instituted or in a suit or proceeding which may be instituted may lodge a caveat. Second, duty of the caveator. Once a caveat has been accepted by the court, he shall serve the notice of the caveat by a registered post acknowledgement due on the caveatee, means on the person by whom the application is expected to be made or by whom the application has been made. Third, duty of the court. After a caveat has been lodged, if any application has been filed in a suit or proceeding, the court shall serve the notice of such application on the caveator. Fourth, duty of the applicant. When the notice of the caveat has been served on him, he shall furnish at the expense of the caveator the copy of his application along with the copies of any document or paper which has been filed or which may be filed by him in support of his application. And fifth, limitation period. The caveat shall remain in force for a period of 90 days. After the expiry of this period, the caveat will automatically be ceased and you need to file a fresh caveat petition. So this is all about section 148A of CPC. Now let us see few points relating to caveat under civil rules of practice. Every caveat petition must be supported by an affidavit and prescribed court fee has to be paid. This caveat will be lodged with the presiding officer of the court, either by the caveator personally or by his advocate. And the caveat must state the name, description, occupation, place of residence and full address of the caveator, and when he is represented by his advocate, the name and full address of the advocate. This address is for the purpose of service and it must be within the local limits of the jurisdiction of the court in which the caveat petition has been filed. Okay, now in addition to these particulars, the caveat petition must also state the name, description, place of residence and full address of the caveatee and the subject matter and the nature of the relief which is to be sought in respect of an application which is expected to be made. And if the application has already been made, then the particulars of the application must be disclosed. And if the subject matter is relating to immovable property, the description of the property is sufficient to identify it. And every caveat will be entered in the register of caveats, which shall be maintained and examined by the chief ministerial officer of the court. He will examine the caveat which has been filed by the party. If he finds that the caveat complies with all the requirements, then he will make an endorsement stating that the caveat has been examined and may be registered. And if he finds that the caveat does not comply with any of the requirements, then he will place the matter before the presiding officer of the court for orders. And last, the caveat which has been filed may be withdrawn either by the caveator or by his advocate on an interlocutory application supported by an affidavit. So this is all about caveat. To know the law in a simplified way, please subscribe to my channel Apurva's Legal Bites.